Okay, so good evening, everyone. My name is Tan. This is the last civil procedure pro bono. Because this is the final few chapters for the syllabus, and I guess the exam is coming soon in 2 months' time, right? So during the last sessions, I'll be covering the final few chapters, and also I'll be picking certain past year questions for everyone to be more familiarized with the past year questions. So let's start with the cost. Actually, the cost itself, it doesn't mean that the cost you have to pay for your lawyers or your engagement of other person. It simply means that the cost that you have to pay into the court. So in this chapter, we will cover what are the types of costs that the court may require you to do so, and what are the purpose and the general rules and exceptions, whether or not you have to pay to the court. Okay, so the definition of cost itself is a sum payable to the solicitor first. This is a very general one. So the sum and also it could be a sum to compensate other party as a result of lose the case. Because the general rule of the cost is the loser pays the winner. So that because you are losing for that case, so that you have to compensate the winner. And what we use commonly in the legal term is the allocator. The allocator is a court fee, so that I'm pretty sure that every one of you have already know how to draft a statement of claim, so that in your statement of claim you will be itemizing special damages, general damages, interest, any other cost that this honorable court deems fit and proper to run. The last relief is the money that you have to pay to the court, that is so-called the allocator. So I've also screenshot one of the example from a judgment, so that when the court has dismissed certain action or the application, you will see dismiss with cost, so that this cost refers to the cost that we have to pay into the court. Is everyone clear? Okay, so also there is a scale that how does the calculation works, because each court has their own different scale of the payment for everything, so that according to Order 59 Rule 22 of the Rules of Court, you'll be given a scale of calculation for each action commenced in different court. Then also there will be a scale. I'll be showing you the scale. This is how does the later I will show you the scale, like how is the court calculating for each action. So if I'm not sure if I've put it in now. Okay. You may refer to your Order 59 and Rule 22, then what I need to pay for court. Oh, Danny, I see your questions already. Why do you need to pay for court? When you file a cost paper, obviously you have to pay to the court, because the court wouldn't do the free work for you. 59. So that essentially when you want to file a case, right, the first thing is whether you are filing an OS or writ, that is a fee imposed on the cost paper. That is also, and also when it comes to, is it possible? Okay, so is that okay? Okay, so to answer Danny's question first, why do you need to pay to the court? It's because that because you also have to pay for the judge, because the judge has given you has been sitting there for so many days during your trial or whatever else. that is the thing, that is also, this is why you have to pay to the court. Is that okay, Danny? Okay, so for the scale of cost, right, I think you all can refer to Order 59 Rule 22. There is a scale like how much does the court will award. So there is a scale of listing on which particular court, what type of action, and how does the calculation works now. So the definition of cost is given under Order 59 Rule 1 Sub 3 of the Rules of Court. So that from here you will see what is a cost. You will see the definition and the term that they use now. So I have taken some of the terms. What we commonly use is cost in any event and also cost thrown away. So basically, the cost in any event is like when you already when the case is already gone into the final, so that at the end of the case, the losing party has to compensate the winning party. And then the cost thrown away, it simply means that when you successfully setting aside a judgment in default, the JID, so that basically when you're setting aside a JID successfully, you will be awarded the cost thrown away. Is that okay for everyone?
Yes, sir.
So we come to the general rules of cost. So that under Order 59 Rule 3 Sub 2, the cost follows the event, which means that what I said earlier, the losers pays the winner. So this is also provided, and I've already highlighted to it, but there is an exception. What are the exceptions? First thing is, it is based on an illegal contract. So that the case on point, right? I'll be using this quite recent case, is Mano Garat Ramasamy. The case fact is that the plaintiff sues a defendant, and he got awarded for the sum. But later on, when he appealed, right, the thing is that the judgment obtained is based on illegality, so that when the thing is fundamentally wrong, you couldn't go into the right way. That is the reason why they reversed the judgment and he got the award for the cost. Is that okay? Another exception is the relevant authorities was not cited. This is the case. The fact is that the appellant filed the appeal without citing the relevant authorities. Therefore, you couldn't be awarded for the cost. No order for cost was given, although the appeal is given. So basically, when it involves the chapter of appeal, right? Appeal is a matter that subject to the court's discretion, but order for cost actually is whether you have complying everything properly or not, so that it wouldn't have any conflict between order for cost and the appeal. Is that okay for everyone? Okay, the third exception, as we can see, is a misconduct or neglect of the winner. This is the case. Okay, for this one, the defendant pays the plaintiff's cost, although he won the case, because the thing is that why the loser has to pay, why the winner has to pay to the winner. sorry, is the winner has to pay the loser is because he did not comply did not comply the rule properly. Is that, as we can see, it is defendant's fault. It is due to defendant's fault, and P has commenced the action, which means that the trial shouldn't be taken place. But you insist on to open the case. That's why you are the one who has to compensate me. I am the innocent party. Okay? And fourth one, this is very unusual. This is very unusual thing because this case is the Petroleum National Berhad. In short form, we call it as Petronas. And the case fact is BMF scandal, the Bumi Putra Bank, Malaysia, something lah. Actually, this you can see in the movie, The Golden Finger, is because of the unlawful acquisition, and then it involves some financial scandal. Therefore, the court allowed for the plaintiff's appeal against the defendant. However, the thing is, the appeal is on the award of costs. Therefore, the appellate court is less likely to interfere with the discretion. So it's less likely to interfere the finding of facts or whatever else because the appellate court is just a rehearing. They couldn't access to the previous judge fact finding, It's like, now I'm rehearing. I am not the one who is sitting there and examining or observing the witness, so that whatever conduct that the previous judge already done, the appellate court did not interfere. I think this one you also have studied in your criminal procedure, right? Because in the criminal procedure, when you are dealing with the appeal, I think there are certain exceptions where the appellate court will interfere. Am I correct? Okay, now it comes to assessment of cost. The assessment of cost actually it's like, how does the calculation be working out? Because according to Order 59, Rule 16, the factors considered by the court when assessing the cost is based on complexity of the case, whether there is any specialized knowledge involved, and the numbers of documents. Basically is referred to the workload that the court is handling. So the second thing is sub-rule 2 and sub-rule 3. Assessment of cost on the standard basis is reasonably incurred by the party being indemnified, so that it wouldn't give you a very, very unreasonable amount, like, oh, it's supposed to be this, but I bill it in the extra cost for the indemnified purpose. And then sub-4, it says the determination of cost is on indemnity basis and shall be accepted except for the reason of it is unreasonably incurred. Is that okay? Okay, now we come to the miscellaneous part, the cost on the different costs, so that for Order 59, Rule 19, the cost payable for trial at High Court, and Rule 20 is for the interlocutory applications in the sub-courts, like what we used to file a notice of application supported by affidavit, the NASA, which I'm always using in the previous slides. And then Rule 21, the cost for interlocutory applications in the High Court. Then is Rule 22, cost on judgment without a trial. So basically, when the question is asking about the cost, right, you just need to flip through Order 59. I would say most of the answers is inside there already. But you just need to be, you just need to, you just need to be familiarized with the order. You are not necessarily to be familiarized with every single rules, because I guess under the panic, everything will go out easily. But at least you know, oh, where should I find it? Then you'll be secure already. Now I'll be guiding you all through the cost involving several parties. The reason why I put Bullock and the Sanderson order is because of we might be suing more than one defendant. The plaintiff might be suing more than one defendants. But the problem is, what if the second defendant shouldn't be involved in the action and you have wrongly sued him and bring him into the action? When the court dismissed with cause, this is the thing that we have to know. So the Bullock order is that when the second defendant is not liable for the action, either the plaintiff or the first defendant has to pay the cost for the second defendant. I'm so sorry, the alignment just went out. Later I will amend and I close it to the group. Coming to another one is Sanderson order. The Sanderson order logic is the same, just that the plaintiff is an insolvent. So does anyone don't understand what is insolvent? Is there anyone don't know what is an insolvent? Okay, so everyone knows what is an insolvent, right? So this is how does the Sanderson order apply. So when the plaintiff is an insolvent party, the first defendant has to pay for the cost for the second defendant. And normally, the court will use the Bullock order because not every time we will be facing the case where the plaintiff is an insolvent party. Unless it comes, then the Sanderson order applies. Is everyone okay? Okay, now we will come to the next one. This is the last year paper on the past year question. This is the 4 marks question, and basically you just need to, when you see when does the court make an order for cost thrown away? So I would say that this is a jackpot question because for 4 marks and there are this. Okay, bankruptcy and insolvent. Bankruptcy is that you are given a judgment by saying that you are a bankrupt. And insolvent simply means that he doesn't have the money to pay. It's totally different word. Okay, so the bankruptcy itself must made by a final judgment, and then you have to satisfy the Section 3 of your Insolvency Act by showing that you have conduct an act of bankruptcy, and then go through the entire procedure, and the court already declared that you are a bankrupt. That is so-called a bankrupt. But insolvent means that you maybe you just have not you just don't have enough money to settle the debt. So that is an insolvent, and it's quite commonly used by us because in our daily situation, right? Maybe there's an incoming payment and then we don't have the money to settle the payment. This is so-called insolvent. It's totally different from a bankruptcy. Is that okay, Danny? Okay. So coming back to this past year question, when you see these kind of questions, right, you just need to copy whatever from order 59.1. It will be more than sufficient already because along with your order and rules, and then you use it correctly, and then you just need to summarize some of the wordings based on the definition of cost thrown away. You can answer this question. The question is already answered. And this one, as we can see, is on 2019 main paper. Cost in the cost, you also can find in Order 59.1. And cost in any event, you also can find in the 59.1 also. Now you can see this one is more like a challenging one. What are the exceptions to the general rule that cost follows the event? So since it is an 8-mark question, first and foremost, you have to start with the general rule. What is cost follows the event first? When you're already written out, then you only outline what are the exceptions like illegality, unusual thing, and those exceptions that I have provided earlier. So this is how we are going to score the 8-marks question, because the logic is that when you see 8 marks to 10 marks question, right? Basically, you have to insert 2 points. So the first point is, what is the general rule? Then you only go to the exception. This is how you're going to score a 8-mark question, say. Okay, for this one, for this question, right? Is any one of you with your rules on call now? Okay, for this question, right, because it's asking, he is worried that the cost of the legal fees cannot be covered. So we can look through, we can flip through the Order 59, the appendix at Order 59 Rule 22. After that, you see an appendix there. That is, okay. Okay, thank you, Mr. Ting. I think yes, it's on page 281. Okay, so basically, this you see, Ali also seek your advice on the amount because he worries that the legal cost may not be covered. So essentially, this is on the cost issue. So that if you look at the part one, the basic cost, um, because I don't have the full question with me at this moment. So if you see the table there, they'll be telling you, oh, on what kind of the action, and then the maximum cost that the court will award is based on that table. So if you are worrying that your legal costs cannot be covered, I'm so sorry, because this is we have to follow whatever costs set out in the rules of court. So that this question is simply asking, like, now my lawyer fee is in the sum of 20,000, and then my and then whatever I have to pay is more than this, so that maybe whatever I claim from the defendant cannot be covered. That is too bad, because you have to follow whatever, you have to bear the risk already, because since you're suing people already, and then now you have to follow to the cost set out by the court. Is everyone okay on this? Yeah, this is the question actually. You see, now machine is for 150,000 paid by way of installment, alleging to forgive. Okay. Now He is suing until, okay, let's say the amount is more than he can afford, then no choice lah. The only thing is he has to accept the fact because we cannot ensure that everyone can get back whatever they want after they got the judgment. Even in the normal action, right, you cannot get back the full amount because after the deductions that you have to pay to your lawyer, you may not get back the full amount of sum, I would say. So this is what does the cost chapter about, and then how does the exam question looks like? Is everyone okay? Before I move to the next chapter.
Hello, sir. Hello.
Yes,
Can you hear me, sir?
yes,
Okay. The scale for cost, right, in by way of Order 59, Rule 23, it
okay.
only covers for subordinate courts. See if it's in the high courts and so on. What do we do? Where do we make our reference to?
Let me check for a while. Sorry, Eli, you're looking at the Rule 23, right?
That's correct, sir. Yeah.
I believe there's a table for high court.
Yeah.
You mean the judgment sum at the list there or what?
As in, there's a scale cost. There's something like this one for Rule 23, right? Do we have such scale for high court as well?
I
Like,
see, I see where you're coming from already.
yeah,
But unfortunately, the entire rules of court binds up to subordinate cost. So that it means that the rules of court, it simply goes to sessions court. For the high court, we are looking at a different rate already. We are looking at a different statute already, the CJA.
I see. Okay, okay. Thank you,
Yeah,
sir.
I hope this answers your question because whatever we have studied here, right? Basically, if you really have gone through the entire syllabus, right? The rules of court is only governing up to the subordinate cost, so that whatever in high court we are using another set.
Understood. Thank you, sir.
Okay, so Ms. Peng, let me see your questions first. But the defendant is asking why is it related to RE? You're very smart on this one. I I can only assume that let me go and see the full questions again, see whether I can find it on my another laptop or not. Sorry, okay, so when I look back to the few questions, right, I guess this is a typo error lah, because what things say that it's true lah. Phone bought the machine from Abu, but to date, it's Ali. So I can only assume that this is a typo error lah. So instead of Ali, it should be instead of Abu, it should be Ali lah, because whatever thing that we have to cover is based on the we have to advise is on Ali lah. So that this one is actually on Ali lah. And then so for this one is this is the reason why I told you all to refer to the scale on order 59, because it shows that, okay, the maximum sum that the court can award. And then if you cannot cover your legal fees, then it is too bad, because that is a maximum amount that the court can award lah. So in this question, right, when you write out order 59 rule 22, and then the scale, then and also the amount. So in your conclusion, unlikely that Ali can do anything further, because we have to follow whatever based in the rules of court, so that you cannot override like, oh, I can advise you this and that, cannot, because everything is inside there already. Is that okay? Okay, we will come to the next chapter, the security for cost. So the security for cost simply means that the defendant can ask the plaintiff to make a certain payment into the court. And also last time I was quite confusing between security for cost and interim payment. So just have to make everyone clear. Interim payment, the logic is the plaintiff apply to the court to order the defendant to make a payment to alleviate the financial difficulty suffered by the plaintiff. And then now the security for cost is because that the defendant is applying to the court to order the plaintiff to pay a certain deposit into the court only. So this is the difference. And then how to apply for security for cost and the factors considered by the court will be discussed accordingly. So the first thing is the purpose for the purpose of security for cost. The purpose is to indemnify the winning defendant. Okay. Rani, in what circumstances security is awarded? Okay. Rani, for your question, I will show you in the subsequent slides lah, because I have covered this in my slides. Okay. So the purpose of the security for cost is to indemnify the winning defendant by the losing plaintiff. So this is what I have said earlier, the difference between the interim payment and the security for cost. So the test for the security for cost, you can look into this case screen. There is a two-stage test. The first thing is whether there is any credible evidence, and then whether the evidence is enough to substantiate the company is unable to pay the cost, because the case is involved because the concern is you want to ask the plaintiff to compensate. Because you're scared that the first thing is you're also afraid that the plaintiff will run away and don't have the money, etc. So the factors considered by the court, we can look into this case. Sir Lindsay Parkinson, there are few factors considered by the court. First thing is whether the application is a bona fide, which means a good faith lah. Then the second thing is whether there is any oppressive conduct by the defendant. The third one is in which stage of the proceeding the defendant made the application. And then the fourth one is loss of money by the plaintiff due to defendant's conduct. Okay, so actually there are certain factors lah, but I just simply picking 3 to 4 factors that easy for everyone's understanding. There are more than this lah. So what I basically use is I'm using the 3 enough already. Because when you're answering the question, I will show you the reason why I say 2 to 3 is more than enough. Okay, how to apply for the security for cost is by way of Order 32(1), which is the notice of application supported by the affidavit. So there are also certain factors considered by the court. First thing is in the case of Le Ching Chai, actually Le Ching Chai is the very famous firm, Le Lam. Le Lam is the firm. He is the managing partner. So that in this case is concerning the defendant wants the plaintiff to make a security for cost into the court. But the court held that even though the plaintiff is a foreigner, it will not suffice the ground for the security for cost, simply because he is a foreigner. If you cannot show that there's no other remedy to recover your cost. And then also in the case of Adarsh Public, in this case, the court held that having a little sum of money will not suffice the ground to succeed for the application for the security for cost. Okay, I'm so sorry. Maybe just now I'm already missing out from this slide. So the factors considered by the court whether or not to grant the security for cost is provided in Order 33(1) sub A to sub D. First thing is the plaintiff is ordinarily resident out of the jurisdiction, which means that he is a foreigner. And then the second one is he is suing for the benefit of other person. The third one is the address is not stated in the writ or the OS or incorrectly stated. And the fourth one is the plaintiff changed his address during the course of the proceeding for the purpose to evade the consequence of the litigation. That is the reason why just now the case of the Le Ching Chai comes in, because in that case, the plaintiff is a foreigner. So the case is concerning that you cannot simply apply for the security for cost just because that the plaintiff is a foreigner. Is that okay for everyone? Okay, for this chapter, I would say it's quite straightforward to me. It's quite straightforward because when you're looking at the questions, right, you see this is the last year paper, and then you see a Thai national having this and that, and then he does not have a permanent address. An average spending 4 months a year in Malaysia and stay in the hotel. Okay, this is the first keyword already. But there are two key factors here. First thing is he is a Thai national. Second thing, he is staying in the hotel most of the time. So it suffices 2 grounds already. And then now he's suing this and that, suing Chong 2 years ago, and then now he wants to file an application. So whether he can do that. So that is the reason why when you see there's a 9-mark question, first thing you have to write out is what are the general rules for awarding the security for cost, Order 23.1. Okay, and then we see whether or not the grounds are suffice. But the thing is very, this is quite tricky because the conclusion of this answer is you have to use the case of lurching child already. You cannot simply file the application for security for cost just because Donald is a foreigner. So after you write out everything together with your service and Parkinson's factors, and then the way how you apply, then in your conclusion, you have to use the case of lurching child. Then this is how you are going to tackle this question. Is that okay? Okay, this is the another question we can see is from 2020 supplement paper. Actually, this question is quite long. That's why I split it into two different slides already. So it says that Aru is a Bangladesh citizen. And then CM has put the contract on hold and repudiated. In the statement of claim, now Aru pleaded that he has no money already lah. He's quite broke already. And then now he wants to know whether the thing can be done, whether the CM can force him to pay the security for cost, because it also suffices two grounds already. First thing is he's not a Malaysian. This is the first ground. Second thing is that he has no permanent address lah. So that in this case, right, since it is a 18 marks question now, you have to be more details. First thing, the general rule, then how to apply, then the facts considered by the court, then fourthly, you have to set the case already, other funding. He has no asset or play. You cannot simply, you may use two cases now. One is the lurching child, another one is the other funded. Because first thing is, how are you going to, who are you advising first? You are advising at the CM. And then because it is a 18 marks question, you cannot run away. You have to tell the examiner, these are the possible defense raised by the other party, but how can we overcome into it? That is the reason why my suggestion more than 15 marks question please don't answer. Because you see, the question is just a short, but the details is more than you have to explain. Unlikely to the 10 marks questions thing, you just need to follow straight to the point. But this one, you have to put some criticism, you have to put some analysis on it already, to secure your answer. That is why for this 18 marks question, you have to raise the possible defense, and then when you make the conclusion, this is how that will work out. You just follow the general rule and then end your answer. That's why 18 marks question somehow, or more than that, more than 15 marks question is very dangerous for everyone to answer. Even for me, I also don't dare to answer for this paper. If I was sitting at that time, I wouldn't answer this. I know the Order 23 is quite straightforward and simple, but when it comes to more than 15 marks, actually, it shows that the examiner is demanding more inputs from you. And I don't think so. I'm steady enough to answer the question, I would say. Yeah, this one is more civilized now. This one, 2021. You see, first thing, non-citizen. Second thing, he stays in hotel. And now he now for the security for cost, we just roll up everything from the order 23-1, and then the application, and then the cases and the factors. We can secure the 10 marks question already. This is the difference between the full marks or very high marks question. The scale, the structure of your answer is different, and then the information that you have to give in is also totally different. Is that okay, everyone? Before I move to the next chapter. Okay. The next one is enforcement of judgment. The enforcement of judgment are actually the key points is the limitation period to enforce the judgment, how to enforce and how to challenge or whether there are any way to and where there are any way to object to the things or because of non-compliance. So according to our section 6(3) of the Limitations Act, the limitation period to enforce a judgment is 12 years from the date of judgment. Mama. Okay, so from this point, we can see that, and also no interest can be claimed after the expiration of 6 years. So that when you got a judgment already, the first thing you have to do is you have to find a way how to enforce it. Whether and the methods of enforcing the judgment I will go through later on. But the first thing is you must make sure that you enforce it within the 6 years' time. Otherwise, you cannot claim for the interest lah. Okay, the reason and also under Order 46 Rule 2, if you want to enforce a judgment for more than 6 years more than 6 years is lapsed, you have to apply for the leave of court to enforce the judgment. That is so-called the writ of execution. Okay. Okay, so as we can see from here, Order 46 Rule 2, the writ of execution to enforce a judgment must accompany with the leave of court if the judgment has been lapsed for 6 years. And then how do you apply for the leave? It's given under Order 46 Rule 3. It's ex parte notice application supported by affidavit. Okay, in the case of Shamsul Baha, I think this one we also will have studied if you take the bankruptcy and winding up in your professional paper, because this is the first thing that you have to determine whether the judgment debtor has commenced an act of bankruptcy as what I can remember the section 3 of your IA 1967. Yeah, so that in this case, the court held that leave of court is required to enforce a judgment after the expiry of 6 years. And also in the case of Affin Bank, the application for leave must be substantiated with reason. Why? Because the whole concept of the leave of court is that the court wants to prevent someone use it as a right. Like, hey, I got 12 years, so what? I can enforce as long as within 12 years. But to limit, to scrutinize, to make sure that everything is done properly, we have to tell to the court, what have you done in the first 6 years? Like, I have already made my effort to locate the person, but the person is unable to find. That is the reason why when you are applying for the leave of court, there must be substantiated with a good reason as your evidence. Is that okay? If you're looking further, this case, Teo Chi Hing, the court granted the leave, because the thing is, usually, when you got the judgment already, the opponent, the winning side lawyer will issue you a letter like telling you, oh, you, because it's a final judgment already, now they're attached with the final judgment and asking you, oh, within how many days you have to make a payment. Otherwise, they will take a one step further. So actually, there will be some rounds of negotiation. If the negotiation takes quite a long time, this is what happened in the Teo Chi Hing case. Negotiation, so that it delays it delays the enforcement of judgment. So maybe sometimes you will see this kind of jokers in the town, like, oh, first round they agree, then later on they change their mind. I don't agree. Then after the exchanging of minds, from 1 month thing can be extended up to 3 to 5 years. We couldn't assure that this is the reason when we are going to apply for the leave of court. You must make sure that your reasons are valid and let the court decide from the facts. Okay, the most of enforcing judgment here are the certain ways . Okay, if 6 years is not lapsed, no need to apply leave, you can still enforce it as of right. Okay, the first way is the judgment debtor summon under the Debtors Act. And then another one is writ of execution, as what I've said, as what I've discussed in the Order 46. And then the enforcement of monetary judgment under the rules of court. This will be covered later on. And then the bankruptcy and winding up. Usually, bankruptcy and winding up may not be frequently used because going through a bankruptcy and winding up procedure is more complicated and then is more time consuming. So that unless and until there is no other alternative, the judgment creditor will only file a bankruptcy or winding up petition against the judgment debtor. So usually, when you see the question on the enforcement of judgment, if you really want to put bankruptcy or winding up, you can use it in the last option, like telling these are the methods of enforcement of judgment. But if there is when there is no other alternative, the judgment creditor is at the option to go by way of bankruptcy or winding up against the judgment debtor. So when we come to the judgment debtor summon, under Section 4, the court will summon or orally examine the judgment debtor to assess the ability to pay the judgment creditor. I'm so sorry, here are some certain double error. I will amend it fast, post it to the group. Then if you want to go through the order 48, this is how does a judgment debtor summon a process, the entire process. First thing is you have to file an ex parte notice of application, and then for the court to decide on how to deal with the issue lah. And then the second thing is the service on JDS to the judgment debtor, and then also the statement of the judgment debtor. And this is the entire procedure, I would say. Okay, now when it comes to writ of execution, it includes writ of seizure and sale, writ of possession, and writ of delivery. So when it comes to writ of seizure and sale, actually, writ of seizure and sale is done by a court bailiff. So that a court bailiff is an officer appointed by the court purposely to execute the judgment. It is not only limited to writ of seizure and sale, because somehow when you see the interpleader, the court sheriff can also have the right to do so. Yes, it's provided in your Order 17 when we're talking about the interpleader chapter. So basically, the interpleader, the court bailiff will also involved in an interpleader action. So that when it comes to a writ of seizure and sales, right, the court bailiff has the power to seize and sell the property. So under Order 55 Rule 12, there are different forms to be used. First thing is Form 84 for the movable property, and then 85 for the immovable property. So to apply for leave to issue the writ of execution is by way of ex parte notice of application in Form 88 supported by notice of application supported by affidavit, basically. And then the lifespan of the writ of execution is valid for the 12 months, but as we know, it's 1 year. And it's renewable by the court. If you file the application to extend the period, it seems like a writ summon is renewable. So for immovable property, right, what we can see quite oftenly is the prohibitory order. The prohibitory order is to prohibit the judgment debtor to transfer, charge, or release the land. I think you all have studied this in your land law, right? So the order for sometimes some people may confuse the difference between order for sale or the prohibitory order or an injunction. So that these are three different things. Injunction is that I want to stop a person from doing something. And then the prohibitory order is a court bailiff step in to prohibit the judgment debtor to do further transaction on the land. And then another one is the order for sale. Order for sale basically is that the court already grant the order, like on which day, time, this particular property will be selling by way of auction. So these are three different things that you all have to understand. I'm not trying to confuse everyone because when some of you all ask me the question, I think to be fair, I think everyone should have a chance to learn now. Okay, the writ of seizure and sale for the immovable property, right? When it comes to the sale of land, under Order 47 Rule 7, the time to effect the sale is 14 days of the expiration of prohibitory order, which means that, okay, now you got a full judgment already. Then the way how we enforce it, and then when the writ of seizure, when the prohibitory order already comes in after the 14 days, then you can sell by the court relief. It's by different person, basically. And at this point of time, the judgment debtor can apply to the for the postpone of sales, and the judgment creditor can also apply to the court to appoint a receiver to receive the rent or profit. But nonetheless, the logic is the same. The order for sale can be set aside on the ground of irregularity or fraud. Okay. Now it comes to the movable property. So the movable property simply means that other than your house, your car, so that under the Debtors Act, there are certain things that the court relief cannot seize. It's the personal effects, which means your personal goods. So you can see from here, the reason why for the personal goods cannot be seized. What comes into my mind is, if you seize this kind of thing, you are committing certain offense. Okay, we come to writ of delivery. So writ of delivery is to enforce the judgment for the delivery of movable property. So it's given under Order 55, Rule 12, and these are the rules that you have to comply with. So yes, I think I have said this just now, the prohibitory order and the prohibitory injunction. So that first thing is the timeline. Injunction can be taken, can be applied before or during the trial. What's come to worst before the judgment. But a prohibitory is after the judgment is given. Then who to enforce the injunction is the plaintiff. But the prohibitory order is a court relief. So these are the two differences that how are you going to differentiate between prohibitory order and prohibitory injunction? And then now we come to second thing is the other methods to enforce the judgment under rules of court. First thing is garnishee proceeding. Second thing is the charging order. A garnishee proceeding under Order 49 is that you are attached the debt from the third party. Let's say now A owes me a certain sum of money. I already got a judgment against A, and now I found out that B is owing to A a certain sum of money. Now I'm going to apply to the court that I want to attach the money from B for this sum, because it comes to my knowledge that B is owing A a certain sum. So it's like offset the sum by attaching from the B directly. So that B can offset the sum owed to A after I set off against him. Is everyone clear for this? Okay. In a garnishing proceeding, there will be two stages involved. The first thing is show cause. Second stage is the further consideration. So in the show cause one, in the first stage, which is show cause, under Order 49(2), the application is by an ex parte notice of application supported by affidavit. In your affidavit, you have to verify the facts according to the order and rules. I'm so sorry I didn't include it here, but at the time when you answer the question, you see the things that have to be included. Then the the rule 3 is you have to serve the show cause notice to the you have to show you have to serve the notice of application to the garnishee who is the so-called third party or the judgment debtor personally, so that the show cause is simply means that the procedures we have to follow, like how do we apply, then what are the other procedures that you have to comply. Now we come to the further consideration. The further consideration is given under Order 49 and Rule 4, so that you have to, the court, what can the court do during the further consideration? Like, as given in Rule 4, if the garnishee fails to attend to the court without any dispute or did not dispute as to the liability, then too bad. The judgment creditor can straight away apply to get the money from the garnishee. And also given in Rule 5, the garnishee can dispute the cost, the liability during the stage of the further consideration. So who can he dispute with? This is shown in the case of the kin builder. The court held that the garnishee may raise a set off against the judgment creditor, not the judgment debtor. The reason why is now is the judgment creditor garnish your money. It's not the judgment debtor. So that the only person that the garnishee can set off is against the judgment creditor. Is everyone okay? Okay. Let's take a look on the 2020 supplement paper. So everyone, do you think that the garnishee, how to answer this question? Okay, I saw Ting's answer is yes. Okay, never mind, we will start from first. So since it's an 8-mark question, so that we have to, how are we going to how are we going to answer this question? Since it's an 8-mark question, so that in this question, you have to first thing tell the examiner how to go for a gunship proceeding. Order for since the year of obtaining judgment is not mentioned, so that we can skip the limitation period. Then the next thing is you are going to explain the procedures of gunship proceeding. First thing you have to say, the first paragraph, the gunship proceeding is like this and that. Then it involves two stage of procedures. First stage is your show cause, rule 3 and rule 4. Then your further consideration is the show cause order is rule 2 and rule 3. Then your further consideration is rule 4 and rule 5. But this is very important. This is the key word. You pay the money into the court. So if you all have the rules of court with you, I would suggest you all to look into the order 49 rule 9. Specifically rule 9 sub 1. So that from order 49 rule 9, this is your conclusion already. However, to advise whether the plaintiff can take back to recover the judgment sum pursuant to order 49 rule 9, it is a garnishing proceeding is not applicable, but you may file a notice of application to the court to recover sum. So that this is very tricky. To be honest, it's really tricky because the first thing is we have only studied quite some rules lah, but not rule 9 lah. So that when I saw this question, I also think that 49 rule 1, 2, 3, 4, 5 only. But until the end of the day, I realized that rule 9 also has to study for a while. So that this question the reason why I share this question because first thing is, at least I have covered this type of question, and if this year comes out again, at least you all know how to answer this type of question now for the 49 rule 9. So that looking at the wording, the sum in the judgment debtor is not entitled, the creditor shall not be entitled to the garnishing proceeding if the money is in the court, but he may apply by filing a notice of application. So this is how are you going to answer the questions. Is that okay? Okay, I've seen some questions on the chat group. Let me see one by one. Okay, repeating on last part, what what plaintiff should do by filing NASA? Cindy, your question is based on this question, right? Okay, so if you're looking at the Rule 9 sub 2, it says that there's a notice of application, but you have to copy everything out from sub 1 and sub 2, which I think at the moment when you write out until Rule 9 sub 1, I think it's more than enough lah. Yeah, because the thing is, this question is only a big mark question, so that if you really generally explain the garnishing procedure and then the procedures involved, then now you already come to another extent is, however, in this situation, it's not applicable because the money is in the court. So when order 4929 applies under sub 1, you can stop it there already. Yes, I think it's more than enough lah. Okay, now we come to another question, which is 2019 supplement paper. In this question, right? Okay, it's concerned that this DEF will define the order, will define the High Court order from the limited information as a bank account and own shares in Kaya and another seizable private limited company substantial assets. Does not want to consider any writing up petition. Okay. From this question is simply quite clear. First thing is mode of enforcement, and then the method of enforcement. And it's quite good for the question is he does not consider any winding up petition, so that at least you already filter out one type of enforcement already. So that basically, you see he has a bank account with ABC Bank, balance sheet, and then he owns shares in Kaya Ridge. This is the charging order which I'll be discussing in the next slide. And then some seizable private limited company with substantial assets, so that it can be done by way of writ of seizure and sale. So that now he wants to protect his legal right and recover the judgment sum. So that you have to list out the following, like garnishing, charging order, and then the writ of seizure and sale. Is that okay? The charging order is available in the next slide, and I will be discussing one by one. Okay, now when it comes to a charging order, right? Actually, it's a judgment creditor to attach the securities of the judgment debtor, like the stock, bonds, shares, and dividend in the company. So it is given under Order 50 and Rule 2 sub 3 of the Rules of Court. And similarly, it also involves two stages. First is show cause. Second is the further consideration. So under the show cause stage, it's given under Order 50 and Rule 3. The application is by way of ex parte notice of application supported by affidavit. And then Rule 4 says that it has to the notice of application has to be served to the judgment debtor at least 7 days before the date of further consideration. Then the next stage is the further consideration. Under Order 50 and Rule 5, the effect of order shall be valid so long as it remains in force. However, in Order 50, Rule 6, the court may discharge the order if it appears cause to the contrary. So when we look back at this question, right? Now, you see, own shares in this company. That is the reason why the Order 50 applies. So you just have to copy everything out from Rule 3, Rule 4 to Rule 6. Then because it's a 12-mark question, you have already identified 3 things already, and together with your introduction and your conclusion, your structure is already there. I would say for 12-mark question, this is how the answer looks like. Okay, we go to another question first. Must be now obtained. Okay. It's not paid. Okay. Okay, so from this 15 marks question, does anyone have idea on how to answer the question? You can post in the chat group. Okay, I can see most of the answers are there already. So to summarize everything, first thing is we look at the information available in the question itself. So the first evidence is owns 1 million of shares in this inovasi modern sebelah Berhad. Okay, first thing is the charging order because the shares. Then the second thing is the substantial assets. So the second one is the rate of seizure and sale. Then the third one completed the office building for the government. This is the third one. The third one, you might have to discuss something extra because although the third one is on the garnishing proceeding, but if you looking at the prohibitions, right? Okay, let me put it here. Okay, so actually there are certain statutes that prohibits the enforcement of monetary judgment. So if you look, the first one is the Government Proceedings Act. No execution of can be made against the government. So in this situation, right, since it is against the government, unlikely that the garnishing proceeding will be allowed. This will be challenged. So that this is the reason why. And then the fourth one, the fourth part is since it mentioned the timeline, as we can see, the date of judgment is on September 2010. So you have to discuss about the limitation period. So in this situation, under Section 6, Sub 3 of the Limitations Act, the limitation period to enforce a judgment is 12 years. However, under Order 46, Rule 2, leave of court is required if the judgment has been lapsed for 6 years. So this is the first thing that you have to discuss, because now, as we can see, 2010 to 2017 has been more than 6 years, and then further to and also as provided in Section 6 Sub 3, no interest can be claimed. Therefore, the interest of 4% is not claimable. And so to guide you all how to structure the first thing accordingly. This is how I structure my answer. First thing is by paragraph. So the first issue you see at the first paragraph is, this is the timeline, the limitation period. So you start with your Section 6 of the Limitation Act, and then your Order 46. So your conclusion for that part is, Pantas Bina may enforce the judgment with the leave of court. However, they are not entitled for the interest on in the judgment sum. Okay, now the second thing is method to enforce the judgment. So the first thing is you have the charging order already, describe the charging order and the procedures involved. The second thing is the rate of seizure and sale, and also the rate of execution, because you already got your 46 month, you already got your leave month. So then you can discuss about the rate of seizure and sale under 45. And then the third one is the garnishing proceeding. However, to conclude your answer, right, you have to say unlikely they can the Pantas Bina can go against the judgment, the government for the enforcement of judgment pursuant to Government Proceedings Act 1956. No execution can be made against the government. If you cannot recall the particular section, so long as you put Government Proceedings Act, then you write out the things already. Your answer for this 15-mark question is secure. Is that okay for everyone? The reason why I say you have to draft your answer based on a paragraph is that this is what I learned from my friend who studied the UK bar, and then you missed out the first part, I think. On which part? The first part is on how you draft the limitation period, is it? Okay, first thing is you're looking at the first paragraph. Your first paragraph there already tell you, oh, he has the 4% interest in the judgment sum, and then the timeline there. So the first part is whether he is allowed to enforce the judgment. So under section 6 sub 3, you have given the limitation 12 years to enforce the judgment. Then you plus the Dr. Shamsul Baha case, or after the 6 years, you have to obtain the leave of court. And also in your section 6, you are not entitled for the interest sum after the 6 years has elapsed. This is how are we going to conclude the first paragraph. So this is what my friend told me. If you identify the question, the issues for the question, right, it's safer that you go by paragraph up rather than you mumble it up lah. Because later on, who knows, the market also got confused because they expect everything to be structured properly. So that if you go by way of paragraph, it will be better lah. So we will go further on for the statutes that prohibits the enforcement of monetary judgment. So under Pensions Act, the judgment creditor cannot attach the pensions of the judgment debtor. And another one, and furthermore, under BSN Act, you cannot attach the money in the banks in Bandar National without the consent of the court. And also, in the EPF Act, you cannot attach someone's EPF. So I think the Pensions Act and the EPF Act, you cannot attach. It's because of the Federal Constitution. Because under Article 5 of the Federal Constitution, it says the liberty of living. So you cannot deprive from someone's liberty from living. That is the reason why these two statutes, I think this is the logic of these two statutes. That you cannot, they're saying you cannot attach someone's money under these categories. Because the pension is the money for the person after their retirement. And then the EPF is also another part of the retirement plan state. So that after you retire or until you reach the certain age that allows you to withdraw the money, that is the reason why you cannot attach. And when it comes to this case, D&L finance per heart, you cannot attach someone's salary. Another one is the merchant shipping ordinance. You cannot attach the JD's the judgment that it occurs wages. Okay, so before I proceed further, does anyone knows what is the difference between salary and wages? Okay, so basically, salary is a fixed sum. However, wages is not a fixed sum. So that is the reason why if you have studied accounts before, you will see this quite often. Salary and wages are different things because salary is a fixed amount and the wages is not a fixed amount. So that D&L finance per heart says that the salary cannot be attached, while the merchant shipping ordinance says that the wages cannot be attached. And then this is also provided in Workmen's Compensation Act. The lump sum or half-month payment cannot be attached as well. Okay, we come to the last year question. You see, a judgment creditor obtained a monetary judgment against the government pensioner when and wants to know whether he can garnish the monthly pension. And then the pension is banked into the account under the bank's Bank National. The pensioner utilizes the pension to support himself and his wife. Advise the judgment creditor if he can proceed to garnish the pensions. So when you're looking at this question, right, you can cite you can use the two statutes. First one is Pensions Act. Another one is the Banks in Bank National Act. So after you cited these two acts, this is how you're going to calculate your answer really. First thing is the Pensions Act prohibited you from garnish the judgment debtor's money, the pension. Then the second thing is, say it's banked into the BSN, you cannot attach without the consent of the court. Is that okay? Now okay. Now we come to the last question. Sorry, this is not the last question. Okay, so this one, this is the last year paper as well, but this is our main paper. The plaintiff obtained the monetary judgment against the defendant. The defendant is a substantial shareholder in the private limited company, wants to enforce the judgment against the defendant. Okay, now you see, it's a substantial shareholder. So that means you may use the you may use the charging order. First thing is because he's a substantial shareholder, but looking at the fact that he also involved in the transport business. Any idea? Okay. I think this one, we have to talk about the company law again. Under the company law, separate legal entity, so that you are suing a defendant. The defendant is just a shareholder in the company. You are not suing the company. Separate legal entity. So when you are suing, if you are suing the company, yes, the company's assets can go by way of seizure and sale. But now you are just suing a shareholder, the substantial shareholder. You are not suing the company. So for me, I would rather say charging order is quite enough. If you unless you are suing the defendant and also the defendant includes the company. Because if you are just suing the shareholder, go against the shareholder enough. If you go for the company, this is how the separate legal entity applies. The director, shareholder, and the company are separated from each other. This is what am I thinking of lah. Any other thoughts? Then I will go to another slide. For this slide, right? For this one, this was in 2019. The question is asking the statutes that prohibit the attachment of the debt in the enforcement of judgment. So this is a jackpot question if you have memorized the statutes that I have listed in the previous slide lah. So I guess the chapter for the enforcement of judgment is ended here. So as of now, anybody got a question to ask before I move to the next chapter? Okay, now we come to the next chapter, the enforcement of a foreign judgment. So it is purely governed under this Reciprocal Enforcement of Judgment Act 1958. In the short form is REJA. So if you cannot memorize the full name of the act, you can find this under Order 67 of the Rules of Court. And then in this chapter, right, I will show you on how to apply and what are the principles and what are the countries that are listed as a reciprocal countries and what are the consequences of non-compliance. So if you want to see the whole REJA, this is the link that you can find in the whole. And then because this chapter, right, I feel that I didn't see this question quite often, maybe just one time only. So that according to Section 3 under this act, there are the list of reciprocating countries such as Hong Kong, Malaysia, Singapore, UK, New Zealand, Sri Lanka, and this and that. So these are the list of the countries. So the Section 4 is the application must be made within 6 years from the date of order. And Section 5 is the ground to set aside. What are the grounds? First thing is non-compliance of Section 3. Second thing is fraud. The third thing is contrary to public policy. So similarly, under Order 67, you will see the application is by way of OS for enforcing the foreign judgment, and then it must be supported by affidavit. And then how do you register the judgment for your application? Then the Rule 7, the notice of registration has to be served to the judgment debtor personally. Then Rule 8 is endorsement of service. So the endorsement is by the process server, which means the runner. The runner has to file the service, affidavit of service, and the timeline given there, and following the timeline given there. And then Rule 9 is how do you setting aside of the registration. this is the only procedures now. And it's not really have a lot of cases to support or guiding. That's the reason why I feel that this chapter is a very, very rare chapter that will come out in the exam. That's why I only found this a very old paper. This is in question 2016. This is, as you can see, Abu Su, a Singapore citizen, and then this and that, and how to enforce the judgment. So the first thing is, since the judgment sum is in Singapore dollar, and then you have to identify, you want to enforce a foreign judgment already. So your Reg 1958 and Order 67 applies. So you have to write out the section 3, and then your Order 67 onwards, the rules. And only 17, and it carries with a 17 marks question. That's why I feel that it's not worth to answer also. That is the reason why when I see this question, I feel so rare, because not that really much information available for us, but a lot of things that we have to discuss in order to satisfy and fulfill the 17 marks criteria. Okay, we come to the second last chapter, is on appeal. So the appeal basically, we are given 2 tiers, as what we have as we all have studied in the criminal procedure. We are given 2 tiers in there are 2-tier legal system of appeal in Malaysia. First tier is if your matter is originated in sub-courts, first appeal to High Court, second appeal to Court of Appeal. Then the second tier then the second type is you originated the case in High Court, then to Court of Appeal, further to Federal Court. And the appeal itself is not may not be as of right, but because it's subject to whether or not your matter is appealable. That's why I start off with here first. The appeal, there is a right of appeal under the Judicature Act, so that under Section 27, the High Court can hear the appeal from sub-court. However, under Section 28, no appeal if the matter is below or less than 10,000 ringgit Malaysia, except the maintenance of wife and children. So that it shows not every single matter is appealable. And then when you appeal to the High Court, the procedure is given under Order 55 of your Rules of Court. And then the timeline of each of the application, Rule 2, you have to file a notice of appeal within 14 days. And then Rule 3, the notice of appeal has to be in what form. And then Rule 3, Sub 2, what are the contents? And then how do you serve? So basically, if your question of appeal is up to the High Court, you just need to copy whatever provided under Order 55 . And then the record of appeal actually is like it's a bundle so that you have to contain the certain the documents contained under Order 55 Rule 4 Sub 1. There are the items from Sub A to Sub H, and then the notes of evidence of law of judgment, and then the memorandum of appeal shall be informed 112 and state concisely under the distinct head and this and that. Okay, so these are the methods that under Order 55 Rule 5 under Order 55 because it goes to the High Court already, so that under 55 Rule 5, the notice of appeal against any decision other than the decision made after the trial, so that somehow we will say that we will see this kind of situation. The judge already give you a judgment, but you are not challenging against the decision, but you are challenging the facts findings and other kind of thing. This is how the 55 applies lah. And then the fresh evidence is quite commonly asked in the question of okay. Okay, Danny, maybe later when I show the past question, we will make. I am not sure whether it's the question that you are referring to in the question now. So what about later? I will see is my partial question containing. Okay, so we go with the fresh evidence first. It's quite commonly seen in the appeal question now. So whether or not the court will allow the fresh evidence, you have to see in Order 55 Rule 7. The first thing is it's not available during trial, and it will influence the decision of the appeal. The reason why they put this requirement is simply because res judicata, whatever you have already used in the first trial, and then the court already gives the judgment based on the evidence, is called by the rules of res judicata. That's why if you want to admit the fresh evidence, you have to satisfy the criteria. And this is explained in the case of Lett and Marshall. And this case, no matter you appeal to High Court, Court of Appeal, Federal Court, when it is dealing with the fresh evidence, just use this case. Okay? Now we come to the notice of cross appeal. So the cross appeal is filed by the respondent. And then under 55 Rule 8, the notice of cross appeal have to be filed within 14 days and served to the appellant in Form 113. Okay, we are coming to appeal to the High Court under written law. So under the written law, right? Actually, this is like something that you are dealing with the tribunal or other statutory body. Like, have you ever heard the Housing Tribunal, Consumer Tribunal, or something like that? So Order 55 Rule 8 is dealing with this kind of matter. So under 55A, the right of appeal is made by the body of persons, simply means that the tribunals. So the procedure is OS and affidavit, and the hearing is also and the hearing is in the open court. The fresh evidence 55 Rule 7 plus Lett and Marshall. That's why I say Lett and Marshall is the mother of the case for fresh evidence in every single appeal. So the further appeal is to Court of Appeal under Section 67 of your CJA 1964. So this one is slightly different from the previous one. So this one is slightly different because the appeal from the registrar to the of the High Court to judge in chambers. So because this is the decision of the registrar of the High Court, it's not by the judge. The registrar is an officer. It doesn't mean that he is the judge, he or she is the judge. That's why if you are appealing against the decision made by the registrar, this is Order 56 applies, like decision in the summary judgment. So the procedure is you serve a notice on every party in Form 114 is given under Order 56. 1, and then the sub 2. And sub 3 is, it says that the notice must be issued within 14 days and served not less than 5 days before the hearing date. And the hearing is before a judge in chambers. Now it comes to the High Court appeal to court appeal. So under Section 67, so the court appeal has the appellant jurisdiction to hear the appeal from the High Court. Then the 68 of the CJA deals with the type of appeal. So in this context, right, there are 2 types of appeal, as of right or with the leave. So we come to the as of right first. So as of right it means that you can appeal without the leave of court. So if your amount being claimed is more than 250,000, yes, it is as of right. And then another one is the judgment of interpleader after the trial. So if your matter is falling under these 2 kinds, you can directly go for appeal without a leave of court. However, if less than 250,000 or the judgment is based on a cost and the summary judgment of interpleader, yes, you have to apply for leave of court if you want to appeal. And what if your matter is consent judgment and the judgment of the High Court is declared final in any written law? Sorry, you are not allowed to go for appeal. Okay, so when we come to leave, right? If the leave is not granted, the last part. So the last part is on no appeal. So Hila, your question is we cannot take anything further. Okay. You mean on this part, right? Or this one? Okay. So I will start with no appeal first now. So if your matter is based on a consent judgment or the judgment of the High Court is declared as final in any written law, I'm so sorry, you cannot go for the appeal. The second thing is, since we already discussed the leave of court for appeal, if the leave is not granted by the appellate court, the matter cannot go for the appeal, and it is the end of the matter already, as seen in the case of non-com. Because the leave is not granted means the court also don't want you to appeal. That's why you cannot go for further appeal already. And your matter will stop at there. Okay? Now, there are certain matters can be appealed as of right under the practice direction. First thing is the certiorari. The certiorari, it means that in order to quash or nullify the decision of a public body. So, to explain this further, I think it happens on last year. It happened on last year. The Malaysian bar filed a notice for judicial review because for the Ahmad Zahid's case. And part of their relief is a certiorari. So the certiorari, it means that you want to nullify the order given by the judge, because the judge already acquitted Ahmad Zahid. So that by filing this judicial review, one of the relief is the certiorari. And this is how the certiorari works. You will nullify the judgment of the previous given by the previous judge. And another one is declaration. The difference between a certiorari and a declaration is that certiorari is used in a judgment. A declaration can be used in any documents, like now it's declared that this document is not a valid document. This is the declaration means. But certiorari is for the judgment to say that, okay, the judgment given by the judge is invalid or nullified. Is that okay? Also, here are the matters like petition for binding are matters related to the Law Reform Act, like marriage or divorce, and judgment for unliquidated damages. You can appeal as of right. How are you going to enter into an appeal? Person to Rules of Court of Appeal 1994 already. So when you're dealing with the appeal, you are using a different rules of release. Since this is a court of appeal, it is governed under Rules of Court of Appeal under RCA 1994. So under Rule 17, the entry of appeal is by filing 4 copies of notice of appeal in the registry of the High Court. And then the appellant must send a notice, a copy of the notice of appeal by registered post to the Court of Appeal. And the notice of appeal, this is how the timeline are. Under Rule 12 must be made within 30 days if no leave is required. And then Rule 6 says that the service is on all parties within 30 days after filing of notice of appeal. And then somehow you can apply for extension of time under Rule 27 by filing motion supported by affidavit with the leave of court. So just one thing to point out, when it comes to the appellate court already, it's not by notice of application, but motion supported by affidavit and review. And the case for the extension of time is Saw King Yap. Factors considered by the court in granting whether or not to grant the extension of time. First thing is the length of delay. second thing is the reason. Then the third one is the chance of success. Fourth one is whether the other party is prejudiced. So just now we already discussed this is the timeline for notice of appeal. Is not leave of court is not required. Then if the leave of court is required, then the application for leave is under Rule 28A of the rules of court of appeal. So the purpose So in the case of Kawashiki, right, the court held that this is actually sorry, I think I've missed out something. Okay, sorry everyone. I think I have missed out uh how to apply for the leave of court of appeal. So maybe I will pull it out and then I will share the link. Okay, I guess I will stop at here first. So for the remaining one, I will be conducting another session, then I will be further discuss on the remaining parts. So I'm so sorry because in a rush already, and also I don't think so it's enough time for us to go through the rest of the chapters. So I will propose another day for the session. I'm so sorry again. So I will be stopped at here and then we'll propose another day for everyone in the group and then we'll all update the accordingly. Is that okay? If I stop here?